for the appellant, Mr. Bacon. You'll have to unmute, Mr. Bacon.
My apologies. Good morning, Chief Justice O'Connor, and may it please the court. I'm Steve Bacon, and I'm here today on behalf of the city of Centerville, Ohio. And with the court's permission, I'd like to reserve 4 minutes for rebuttal. The primary question in this case concerns when a municipality is to be considered a victim of crime and entitled to restitution under Ohio law. Now, this question is answered by 2 provisions of Ohio's Constitution, and they're both set forth in Article 1, Section 10A concerning victims' rights. Now, these provisions were overwhelmingly approved by Ohio voters in November of 2017 as a part of the Marsy's Law Crime Victim Rights Initiative. The first of these 2 provisions defines who's a victim and who is entitled to the mandatory rights set forth in Ohio's Bill of Rights for victims of crime. And that definition is set forth in Section 10A at letter D. And it states that a victim means a person against whom the offense or criminal act is committed, or who's directly and proximately harmed by the commission of the offense or act. The second of the 2 provisions addressing this question is set forth in Article 1, Section 10A at letter A, item 7, and there's a list of the enumerated rights of victims, and states that a victim shall have a right to full and timely restitution from the person who committed the crime. Now, these 2 provisions taken together effectively mandate the proposition of law offered by the city, that a municipality qualifies as a victim under the Ohio Constitution's Bill of Rights, Section 10A of Article 1, and known as Marsy's Law, and is entitled to full and timely restitution when it's directly and proximately be harmed by the commission of a criminal offense or an act. Now, under this proposition of law and in the context of this case, this means that Centerville would qualify as a victim of crime and would be entitled to restitution for harm it suffered as a direct and proximate result of Michael Knab's criminal acts. Now, Mr. Knab was convicted in the trial court of 2 crimes: making a false report to a law enforcement agency and improper use of the 911 system. These crimes arose, or these convictions arose, from an April 3rd, 2018 incident in which Mr. Knab called the 911 and reported to the Centerville Police Department that there was an active shooter in his home, that individuals were injured. Well, it turned out these statements were false. There was no shooter. There were no injured people, but Centerville's a relatively small city. And so this crime required it to allocate all of its resources to respond to this call. So the trial court awarded restitution to the city, and I believe it was under the improper use of the 911 system conviction, for the cost of officers' time in responding to that call.
Counsel, I wonder if you could respond to the question addressed in the Court of Appeals opinion, which is, in this situation, the city was paying its officers whether they responded to that call or not. And so even if we would agree with you that under some circumstances, there might, the word person might be able to include an entity other than a natural person, why would it be extended here where the city was acting in its governmental capacity, and the costs that it was incurring would be costs that they would normally incur?
Well, when you look at the first part of your question, I think that concerns, whether the cost would have, been incurred otherwise in that. And I think when you look at this, there were not just the regular patrolmen who were out on their duties, but in this instance, there were also detectives who have other duties. There were also command staff. There were multiple people brought in that were taken away from their other normal and regular duties and required to serve and respond to this particular call. I think there were 11 personnel and a dispatcher devoted to this one thing, and those people normally have other duties or normally performing other jobs, and the city lost those resources. As to the issue of governmental versus proprietary function, I think you have to look at the fact that, as provisions of Ohio's constitutions, Marsy's Law is the supreme law of Ohio. It's an expression of the will of the people, and I think it expressly states that it supersedes and that it is self-executing. So when the Court of Appeals was looking to prior case law interpreting the restitution statute, it shouldn't have been. It should have been solely looking to the definition set forth in Marsy's Law, because that prior law had been superseded. And
Counsel, are you saying that the standard of finding a loss is no longer to be employed here? You just look at the definition of victim and that's what controls?
I would say that the standard for loss, because there's been some concern expressed in various amicus briefs as to how this will be applied, is now set forth by the definition of victim in terms of direct and proximate harm. If you look,
So, Counsel, it's not necessarily loss that is the harm. You're saying that it's an all-encompassing, harm is all-encompassing, including loss. Is that what you're saying?
yes, I think that would be a fair interpretation of that.
But here, there was no loss. They didn't pay extra wages, did they?
They did not pay extra wages, but while time may be fungible, work isn't fungible. If I'm taken away and if cities lost the resources of multiple officers, multiple command personnel from their regular job, and then that has to be made up differently or has to be used in a different manner, they've reallocated resources. They've essentially lost that time. They've essentially lost that ability to recover or to use those resources as they'd allocated.
Were there calls that went unanswered? Were there other citizens that did not have police resources as a result of this?
That was not discussed or that was not covered in the restitution hearing. And I would say in this instance, there's something unique about the crimes here. This is abuse of a 911 system or improper use of a 911 system, as well as a false report to an agency. While Marcy's law defines a victim in terms of someone who suffers a direct and proximate harm as a result of the crime, it also entitles people to restitution for injury suffered as a result of the act itself. And if the improper use of a 911 system as an offense is directed towards anyone, it's directed towards the municipality who receives the call and is deprived of their resources.
But if we accept your argument, it's not limited to 911 calls. I mean, it would be any crime the government would be entitled to restitution for. Under kind of the definition you propose, correct?
And no, I don't think it'd be for anything, Your Honor. I think there's a check on this. Now,
well, what's the check then? Explain from the definition you propose how you get there.
It's from the direct and proximate harm. We use the concept of direct and proximate harm in court.
Right, but isn't, you're saying the direct and proximate harm here is that the city had to expend resources as a result of his crimes. Isn't that the case in any crime?
Oh, well, I don't know that it's in the case of any crime. And I think that the question in this is,
well, why is it different? I mean, what makes this different then?
Well, in looking at a direct and proximate harm, you have to look at whether, I'm looking here for the phrase that I'd like to make sure I'm quoting from that. An act or omission which is within the natural and continuous sequence of events directly produces the injury and without which the injury would not have occurred.
Well, isn't that the case of any crime then? Doesn't any crime naturally lead to an investigation of that, which leads to the expenditure of taxpayer dollars?
I think that that's a factual determination to be made on a case-by-case basis.
So what would be the defining fact then?
I think you have to look and see how approximate cause applies in each particular.
Well, you're just saying the same words over and over again, though. Proximate cause. Why wouldn't the proximate cause of any investigation be the crime?
Well, it has to be an act or a sequence of acts without which the injury would not have occurred.
Right. Again, and why wouldn't the proximate cause of any investigation be the crime that led to that investigation?
I think that there are resources that are normally allocated towards, say, patrolling or towards investigation. But when outside or exceptional resources are brought in, that creates its own particular.
So proximate turns on whether it's exceptional. Is that?
I think
if there's a lot of investigation, that makes it a proximate cause.
I think proximate turns on whether it was an event without which the injury would have occurred. I think it would be more clear in this instance if there had been overtime costs. It would be more clear in this case if certain other special services had to be incorporated. In this instance, it's particularly murky with regard to the patrolmen who are already on call and who are already responding. But in this case, it's the additional resources that were expended that were.
So the test, it's an overtime test if only if you have additional police officers who aren't on duty, then it's approximate cause?
Not an overtime test. It would be whether the injury would have occurred without the act.
And again, I still don't see from that how we write a rule that would apply to other cases. But
I think the rule would be, Your Honor, that a municipality can qualify as a victim when it's directly and proximately harmed. Now, there may be a determination which needs to be made, as you know, on a case-by-case basis or as the law develops, as to when that injury occurs and when it occurred or wouldn't have occurred but for that act. I mean, yes, there are resources allocated to investigation and police work, which are there on a day-to-day basis, but there are exceptional amounts and times when there's exceptional effort expended.
do you think that when the average voter went to vote on this amendment 2 or 3 years ago, they thought they were creating rights for municipalities?
I think that a person has always included artificial entities created by law and recognized.
So, I mean, do you think that's the way the average voter who went to vote on this amendment would have understood this amendment?
I think we attribute knowledge of the law to the voter, and I think that we have to assume that under the law.
So is the question whether or not the municipality can be a victim, or whether or not what happened here created harm?
Your Honor, I think it's the first one, whether a municipality can be a victim.
Well, didn't you just say that you know the law's pretty clear? Is that your position? The law's clear that artificial or you know non-human entities can be victims. Is that universal?
I think under the law as written for Ohio, I can't say universally. I've not seen the issue addressed for other states that have adopted Marcy's law. I know that when the term person is not defined, the U.S. Supreme Court in Cook versus Chandler noted that it commonly includes artificial entities and specifically noted that includes municipal corporations. As to your first question, I believe the issue accepted to review by the court was whether a municipality can be a victim when it suffers an injury as a direct and proximate result.
Well, okay, so you're a victim whether there's an injury or not. If you're involved in some way, I mean, Marcy's law is pretty expansive. And whether or not you can quantify your harm or your damage or your loss, you still can be considered a victim. Is that what you're saying?
I think when the act is directly against you, yes, you are considered a victim. Now, you still have to, a restitution is a make whole remedy. So there has to be something for which you're made whole. So it's not just, oh, you're a victim, and so now you're entitled to something. You have to be made whole. But as you said, the issue isn't in this instance whether it was an economic loss. That was the second proposition of law, which actually wasn't accepted for review in this court. But rather, it was the first proposition of law, which whether a municipality can be a victim of crime. So, Your Honor, in this case, I think we find that the direct and proximate requirement acts as a check on any concerns of the amicus briefs with regard to the application of the law. And I think that the U.S. Supreme Court has pretty clearly indicated that since 1863, a person is including a municipal corporation. We think that a municipal corporation should be considered a victim entitled to restitution whenever it suffers harm as a direct and proximate cause or direct and proximate result of a crime, or as well when a crime is directly committed against it. We'd ask that you reverse the Court of Appeals and remand the case for consideration inconsistent with this court's opinion. I'd like to save the remainder of my time.
Thank you. Mr. Clark.
Chief Justice O'Connor, may it please the court. Centerville is asking for restitution to pay for the hourly wages of government employees. This is a budget subsidy from one of its residents for costs that would have occurred on April 3rd, 2018, even if Mr. Knab never called 911. But this case is about more than restitution. Other rights, unremarked upon by Centerville, are at stake for victims. If the constitutional definition of victim is broad enough to include municipalities, then Article 1, Section 10A of the Ohio Constitution would give other rights to city governments from the moment a complaint is filed. These additional rights may include the ability to fight otherwise routine discovery requests except as authorized by the state constitution, leading cities to fight over whether they need to comply with Criminal Rule 16. Speedy trial rights for municipalities could harm a plea bargaining process that is preferred by people who are actually victimized.
Counsel, let me ask it this way. If a perpetrator bombed a city building, can the city recover in restitution for the cost of that building?
Under existing statutory and case law, yes. There's no need for Marcy's law to permit that.
But aren't they, the city would be a victim in that case, correct?
They would be under statutory and case law, but under Marcy's law, I don't believe they would.
You mean they weren't directly harmed by the blowing up of their building?
They were directly harmed, but they are not a person for the sense of the definition of victim in Marcy's law. And there's good policy reasons, of course, to allow restitution in those circumstances, but we don't need Marcy's law to guarantee that. And we know that municipalities are not victims under Marcy's law from the text of the constitutional amendment, from its own internal structure, and from the relationship between people and municipal corporations in the broader structure of the Ohio Constitution. So this court should hold that Article 1, Section 10A of the Ohio Constitution does not give municipalities any procedural or substantive rights.
Counsel, if the city had to, in this circumstance, bring in more staff, more police, brought in the SWAT team, that were off duty and they're now getting overtime, and there's equipment and there, et cetera. Would that be covered under the other statutes that you're talking about rather than Marcy's law?
Not currently, but that's still, and I want to emphasize, this does not leave the city's hands tied, because defining a city, a municipality, as a victim under Marcy's law starts to walk into the constitutional thicket that Justice DeWine was beginning to draw a context around with the questions he asked earlier. And excluding municipalities from the definition of victim allows the debate, the policy debate, about when city governments are entitled to criminal restitution to flow through traditional democratic channels. And the
so right now you're saying additional expenses that are incurred as a result of any kind of criminal activity. I mean, how far would this go? You're bringing in people and doing, paying them overtime, et cetera. That's not recoverable right now, just because that's the business of the police department.
Well, there are crimes for which it would be recoverable. And the fact, for example, the pattern of corrupt activities statute allows for restitution for investigative expenses out of a recognition that investigating that kind of crime can be very expensive. And what that shows us is that the General Assembly is more than able to carve out situations in which municipal restitution is appropriate. And we should leave that question to the General Assembly. Defining victim as including municipalities for overtime expenses becomes really thorny as a factual matter, because some expenditure of municipal expenses or municipal resources is discretionary. How a city responds to a crime plays a role in how expenses are incurred. When we're looking at those fine lines, we should leave it to the General Assembly to draw those fine lines, and we can, because Marcy's law does not compel the outcome that is sought by the city. I want to go to the text of Marcy's law now and speak directly to the Chandler presumption that the city referenced. The Chandler presumption that municipalities are people does not apply here for a couple reasons. The Chandler court was clear that the presumption is just a presumption that can be rebutted. It is for three reasons: the history of municipal corporations in Ohio, the competing State versus Carswell presumption that this court has for how to interpret fruits of direct democracy and the proponent language in that was used to support the Marsy's Law campaign. So first, the Chandler presumption is based on case law from the early 19th century, including Amity and Cowles. And the history of municipal corporations in Ohio shows that municipalities today have broader governmental power than municipal corporations did in the 19th century when that presumption was developed. And that's because of Article 18 of our Constitution, which is not cited once in the state's brief. Article 18 gives municipalities home rule rights, and it was adopted in 1912. Amity and Cowles, which are the two cases that undergird the presumption in Chandler, were decided long before 1912 and have not been cited in Ohio since 1912 for the proposition that the city seeks to argue. This is because the broad definition of municipal corporations as understood in the 19th century does not apply to municipal corporations as they are understood in Ohio. And to answer the question of whether municipalities are people for the purpose of Marsy's Law, we need to look to State versus Carswell. State versus Carswell says that there's a presumption that the revised code supplies definitions of general terms in an initiative. So we look to revised code section 1.59, which defines person as an individual, corporation, business trust, estate, trust, partnership, and association. But just because the word corporation is in that general definition doesn't mean municipal corporations are. I'm sorry, Justice Fisher, did you have a question?
I understand your argument on that. I was going to refer you to Article 1, Section 16 of the Constitution. I look at the Constitution for the definition. It says all courts shall be open and every person for an injury done, they have an opportunity to go to court. Don't municipal corporations fit that definition of person?
No, because we looked at Article 18 to define municipal corporations if we're looking in a constitutional sense. And the only time that person is referenced within Article 18 is to suggest that municipalities may contract with people and may do other things with people.
So Article 1, Section 16, the municipal corporations can't go into court and sue?
Municipal corporations can go into court and sue. But if we look at Article 1 broadly, we're looking at rights that refer to individuals. The powers that the Constitution defines our municipalities not in terms of rights they have against the government, but in terms of positive power that they have to exercise as governments. And throughout the revised code, and we presume that these statutes are constitutional, there are specific narrower definitions of person for specific chapters that include municipal corporations. For example, revised code 101.70 says that for the purposes of lobbying the General Assembly, municipal corporations are people. There would be no need to include that additional language in revised code 101.70 if in fact the general definition of person included municipal corporations. Further, we look to statutes in the revised, there are areas of the revised code where we moved from a common law regulatory scheme to a statutory regulatory scheme. Two examples are revised code 3734.10 and 6110.08, talking about riparian rights. And in those cases, there's a private right of action carved out for both people and municipal corporations. We would not need to carve out that private right of action for both people and municipal corporations if our law understood municipal corporations to be people. Finally, I think that we need to look to the proponent statements in support of Marsy's Law, because those proponent statements are consistent with the Carswell presumption that municipalities are not people. The proponent statements spoke in terms of individuals and families and giving victims dignity interest. And while it's absolutely true that Marsy's Law was broadly supported by the Ohio public, it's less than clear that the broad Ohio public would have supported including municipalities in the definition of person, especially because doing so, as Amiki argued, could put municipalities into direct competition over restitution resources with those who we more commonly think of as victims, including domestic violence victims and human trafficking victims. So it's important, I think, to look at those statements because person is a contested term. And when we're interpreting the fruits of direct democracy, there's no legislative debate or deliberation about what those terms mean. It's an up or down vote. And the way to ensure democratic legitimacy of these fruits of direct democracy is to define those terms narrowly and let the debates outside of those terms be taken care of by the legislative process.
Counsel, does Marcy's law have language in that constitutional provision that says this trumps all other statutes, that would be contrary to what is the contents of Marcy's law?
Yes, it does aggregate sections.
So if they redefine victim in the Constitution, does that not take care of the argument that you're making that in some statutes, the municipal corporation is added specifically, which you say is a conscious effort by the legislature to do so, whereas when person is just referred to in other sections, it only means an individual, not a municipal corporation? Doesn't the blanket language of Marcy do away with those distinctions you're attempting to make? Because they would be contrary to the definition of victim in Marcy's law.
I'm sorry, I didn't mean to interrupt your question, Chief.
Okay.
No, it would not in any sense, because my arguments go to how the definition of victim in Marcy's law is defined. So my argument is that person, as part of the definition of Marcy's law, is not capacious enough to include municipal corporations. And to the extent that municipal corporations would seek restitution, the General Assembly can always pass additional laws that don't conflict with Marcy's law, expanding municipal restitution. Further, Marcy's law would not abrogate the current case law that provides for municipalities to get restitution in some circumstances, because that case law and that statute in that context does not conflict with Marcy's law.
Counsel, do you believe that the city here, that the activity of your client was against the city, the false 911 call and what he was convicted of, that was done against the municipality, correct?
Yes, I think calling 911 does expect the municipality to expend resources, but it didn't harm the city here
but that's not the, I mean, I guess you don't have to have harm in order to be a victim.
True, but to the extent that there's going to be divisions about municipalities being able to recover in proprietary context, but not governmental context, looking to the harm is necessary to define when a city might be a victim, if there's room in Marcy's law for cities to be victims. And if that's the nuance that the court is going to walk down in this case, this is the wrong case to do so, because there was no harm. And there will be a situation in which the issue is more squarely presented. So this court should consider dismissing this appeal as improvidently accepted, should we start to look into more nuance about when municipalities may be victims and when they may not. One last point I want to make: the broader structure of the Ohio Constitution supports this argument, because there's an entire section of the Ohio Constitution devoted to municipalities, what they may do, what their rights are as against the state government. And Marcy's law is simply not referenced, not talked about, not discussed at all anywhere in Article 18. Marcy's law protects crime victims, not the government. Should the city seek a broader right to restitution, it should take this request to the General Assembly. I ask this court to affirm the second district.
Well, which is it? You want us to IA it, or you want us to affirm it?
I would be happy with either. I think that to the extent that the court wants to address the question here, the court should affirm the second district. To the extent that this case does not squarely address some of the nuances that were discussed in oral argument, IANA is appropriate, and waiting for a more squarely presented case would be appropriate.
Thank you. Counsel, you have a little more than a minute left. You'll have to turn your mic on.
Thank you, Your Honor. And looking or thinking about Mr. Clark's comments, I think that it's a question of whether you're putting the cart before the horse. I think, as you noted, that Marcy's law supersedes the existing law. It supersedes the prior application finding limitations on a government's right to recover restitution. Instead, Marcy's law just simply defines who's entitled to restitution in terms of proximate harm or in terms of who the crime is committed against. Now, if the legislature wishes to change that, there are certain rights which a municipality doesn't have with regard to due process against its enacting or enabling state, the state that creates it. But that's up for the legislature to do if it finds that the law is being improperly applied. So the legislature could provide a remedy to any concerns expressed by the amicus briefs, but instead that should be addressed by the legislation prospectively, and it shouldn't be applied on the front end in an attempt to essentially rewrite the statute. And then looking at this, I think if you're looking at the Cook decision, that Cook decision is from 2003, Cook v. Chandler. It's not something long ago or only dealing with something from a time which doesn't exist anymore. It's within the last decade or so. So in you looking at that, I think it's clear that a municipality can be a person under Ohio's Constitution, and that Marcy's law, as written, provides the municipality a right to be a victim. The issue of when exactly it experiences harm in that isn't directly before the court today, but I think it's entitled to restitution whenever it experiences harm as a direct and proximate result of a criminal act. So we would ask that the court reverse the Second District Court of Appeals, issue a proposition of law or issue a finding of law consistent with the city's proposition, and remand it to the Court of Appeals for further review.
Thank you. Thank you. We'll take the matter under advisement. You'll be notified of our decision. Our second case this morning is 2000.